Commissioner Ben-Veniste.
Thank you, Mr. Chairman. And I'd like to join my colleagues in thanking you for your appearance today and your insights and the amount of preparation that's gone into your presentations this morning. I start my analysis of the balance between the need for greater intrusiveness into the privacy of United States citizens with the observation that our intelligence with respect to the 9/11 hijackers was pretty good prior to the catastrophe that took place on 9/11. Where our law enforcement and intelligence community failed was in utilizing the information that was available in a way that could have interrupted the plot. I would note that nothing that I have seen so far in the course of our investigation on this commission has caused me to change that assessment. The changes that have been put in place since 9/11 have, on the other hand, created an atmosphere of concern over government intrusiveness with respect to the privacy and free speech rights of our citizens. There has been anecdotal information put forward, and so I caveat it at that point that individuals who have been involved in protests regarding the Iraq War have wound up on no-fly lists and have been treated in a way that makes them suspect that perhaps their names have been added by reason of their political action. With that preamble, I would like to put two questions. First, what assurances are there, if any, that expanded powers given to law enforcement to combat terrorism have been or are likely to be used for ordinary law enforcement not related to terrorism? And historically, I would put forward the example of the RICO statute, which was designed to combat organized crime, but has since been utilized in every conceivable way having nothing to do with organized crime. And secondly, given the concern that legitimate free speech and privacy rights may be infringed, and given the enormous effort now underway to accumulate and disseminate databases with respect to United States citizens, something we're going to deal with a little bit later in these hearings today, I want to call your attention to a recent FBI intelligence bulletin and get your comments. This bulletin came out on October 15th, 2003, and I'll just quote very briefly from it and get your comments about this bleed-over effect. The intelligence bulletin, which is circulated to federal and state and local law enforcement agencies throughout the country, says on October 25, 2003, mass marches and rallies against the occupation in Iraq are scheduled to occur in Washington, D.C. And then it talks about potential violent or terrorist activities associated with the protests. It goes on to say, even the more peaceful techniques can create a climate of disorder. And they use as examples obstructing traffic, possibly intimidating people from attending the events protested. It goes on, extremists may be prepared to defend themselves against law enforcement during the course of such a demonstration, and some of the indicia of extremists protecting themselves are the wearing of sunglasses and layered clothing. Activists may also use intimidation techniques such as videotaping. And then it concludes that the law enforcement agencies are encouraged to report any potential illegal acts to the nearest FBI and Joint Terrorism Task Force. By this, I think you can see that the definition of terrorism and terrorist acts or violent acts is particularly squishy with regard to this bulletin, and it, of course, created something of an uproar. And so my question with respect to that is, are we overreacting? Is there the potential for creating a climate in this country that is so counterproductive to our ideals that we ought to look at it mid-course and make some suggestions regarding correcting it? Professor, why don't you take the first crack at those?
I've had the consistent opportunity to get in the last word criticizing, so it's only fair. First of all, first question was, what assurances do we have that the expanded powers won't be used for unrelated purposes? We have no assurances, and quite to the contrary, the Justice Department acknowledges that it has used these powers for unrelated purposes, particularly the Justice Department document USA Patriot Act Myth versus Reality, which I believe is September '03. In the course of debunking myths such as the fact that the powers might be used for unrelated purposes, the report itself documents, and separately for each section, the instances in which they've been used, and it documents specifically instances when they were used to investigate the theft of trade secrets, investigate extortion, investigate what they called narco-terrorism, which I believe is drug trafficking, and so on. It's all made very explicit. So we know that this is being done. And it's inexcusable because it's very simple as a matter of draftsmanship to do what the Patriot Act does in most of its sections, which is to say that these are for purposes of a terrorism investigation. Secondly, about the ability of this to bleed, I believe your question into particularly sensitive areas of political protest. I think your question indicates itself how quickly we've moved in that direction. And we thought we had learned this lesson in the 70s with the FBI guidelines that were adopted by Attorney General Levy and President Ford, which laid down rules intended to prevent the overly wide sweep of information that could intimidate the expression of First Amendment activity and that could be misused for inappropriate purposes. Among other things, and I don't want to disparage the importance of First Amendment rights. It's extremely important, but I think it's also important for the public to understand that we don't get more security this way. What we get is an incredible misuse of FBI counterterrorism investigative resources, which, as we have heard, are stretched very thin, and they're to be used to prevent the obstruction of traffic in cities. So it was with this in mind that the FBI guidelines adopted in 1976 structured this to try to prevent this type of abuse. And one thing that happened on May 30th of '02 was that the Attorney General announced very substantial changes to those guidelines that in effect relaxed and obliterated, unloaded many of the significant restrictions that had been in place since 1976. And again, I try to make this answer brief, so I would just say again, this is another instance of a change that's totally unrelated to terrorism, because the guidelines that were changed, the FBI guidelines that were changed, were not the guidelines that governed international terrorism investigations. They were the guidelines that governed the investigation of general crimes, and I have yet to hear an explanation of why that was necessary. So are we overreacting? I think it's demonstrable and not debatable that we have overreacted in ways that not only damage our liberty unnecessarily, but they are counterproductive, and they foster mistrust and a sense of oppressive surveillance, and they foster alienation in the very communities whose help we need if we're going to win this fight. Thank you.
Larry?
Yes, Commissioner, the professor and I have been on another panel, and he did a great job. But I'll try to give you an explanation as to why we made some of the changes in the guidelines, because we carefully reviewed those guidelines and with respect to making changes that we thought was appropriate. And Commissioner, you pointed out the fact that there was intelligence with respect to the individuals that were involved in the 9/11 attacks. And there was information in the system about those men. But one of the problems I think we had prior to 9/11 is that we had a paradigm, certainly in the law enforcement community and perhaps throughout government, which was a reactive philosophy. In other words, we were going to wait until something happened, then react to it, then investigate the heck out of it, and prosecute the individuals who were responsible for the events. And it was crystal clear after 9/11 that we had to undertake a different approach, and we had to focus on prevention, and we had to be proactive, and we had to undertake measures that were designed to detect and prevent terrorism at the very beginning. Now, that does create the tension that the professor talks about, and we certainly cannot overreact. But we do need to develop a situation in which our law enforcement officials can undertake activities, especially activities that are open to the public, that are designed to detect instances of terrorist activity. I do not know what the underlying intelligence was as it related to why the FBI authored that memo. I have not reviewed it. But we have to be careful. I agree with you. We have to be careful. But on the other hand, we have to be ever vigilant in terms of doing what we can to be proactive. The one thing that the Attorney General and I, though, were very concerned about when we reviewed the guidelines was to make crystal clear that while you could undertake activities of a public nature that were designed to detect terrorist activity, you could not undertake activities that were designed to interfere with our citizens' constitutional rights, rights that were protected by the Constitution or other laws. And that's a fine line, and it's a judgment, but law enforcement officials make judgments every day. So I would just respond to the memo, and that is, I think it's important that we have to continue this new paradigm of prevention and disruption, and we have to be proactive with respect to what we're doing. But we cannot interfere with activities that are protected by
What are you protecting against, and what are the disruptions? In that memo, it doesn't appear to me to be related to the kind of terrorism that we're concerned with. But
sir, I would agree with your comment, except that I don't know the underlying intelligence that led to that memo and perhaps some of the unfortunate words that were used in that memo.
Just one follow-up to your answer, Mr. Thompson, and that is with respect to the changes that have been put in place post 9/11, which is, after all, the central focus of what we're involved with in this commission. Other than clarifying rights under FISA, which the FISA court incidentally said was unnecessary, but other than that, can you point to any particular aspect of what has been changed since 9/11 in our laws that would have directly impacted on the interruption of the 9/11 plot?
Other than the
clarification of FISA, which the FISA court said was simply a misreading by those who were applying FISA of the terms of FISA.
But Commissioner, that misreading had been in place when I got to the Department of Justice, and it was certainly the way we were doing business in the Department of Justice.
That's why I say, putting that aside, is there anything else that has been enacted since 9/11 that, in your view, would have likely resulted in the interruption of the plot?
Enacted is a narrow word, but I would say this, that if we had in place, system-wide, government-wide, a paradigm that we were going to do everything that we can to prevent and disrupt terrorist activity, that we were going to share information. Perhaps that paradigm, given what we now know that we knew about the hijackers' activity, perhaps, I don't know, but perhaps we would have been able to do a better job with respect to investigating, those activities.
That's a question of focus rather than law, isn't that right?
Correct. That's. May I respond to your point, Commissioner, about the Patriot Act provisions? Many of those provisions are general criminal law provisions, and I think it would be difficult, but more importantly, I think it would be inappropriate for the Department of Justice and federal prosecutors to limit those provisions that are in Title 18 that are designed to go after crime to any particular kind of criminal activity. And if a statute applies to general criminal activity that may be terrorism, but it may be bank fraud, it may be money laundering, I think you should use that statute to its fullest extent to go after that particular
Well, thank you. And I'll leave with the observation that some who were skeptical about how the Patriot Act was passed and the time that it took to pass it and what was included in it have suggested that many of the provisions were essentially on the shelf on the wish list of law enforcement. I see you smiling. Prior to the catastrophe of 9/11, and as you have said, have not been restricted to use only to combat terrorism. Thank you, Mr.